Very good. Ms. North and Ms. Anderson, I see you both in the courtroom. So we are ready to proceed with Ms. North when you are.
Thank you, Your Honor. May it please the court, my name is Kristen Norris, and together with Stuart Markman of Kynes, Markman, and Fellman, we represent Jerry Jaramillo. I'd like to reserve 5 minutes for rebuttal.
Very good.
Thank you. This is an appeal of a temporary order in a dissolution of marriage case that imposes over $24,000 a month in support obligations after a hearing in which only the wife was permitted to present her case. The order should be reversed not only because the trial court denied the husband a continued hearing to present evidence in defense, but also because it entered an order that fails to make the findings the law requires, is not supported by competent evidence, and would exhaust what even the wife's accountant testified was the identifiable income of the husband. This case is really controlled by three principles of law, controlling principles of law, each of which would require reversal. And the first is that this court has consistently held that it is error to enter an order on temporary relief without providing a party an opportunity to present evidence in their defense unless three conditions are met. First, there must be emergency circumstances. Second, the court must make an award that is an interim award and that is reasonable in amount. And third, the court must offer additional hearing time to hear the other side's case. This court has consistently applied the rule in Priestes, Cord, Henderson versus Lyons, Douglas versus Johnson.
Ms. Norris, help me out because I fully suspect we'll hear this from the other side. So just kind of cut right to that matter of the hearing time. Is it correct to say that the parties set the amount of time, they agreed upon the amount of time that they wanted to have this issue on temporary relief heard? In other words, they chose, I think it was a 3-hour block, wasn't it?
Right. The wife had requested a 2-hour block and she said she cleared that with the husband. I think that's what the record shows.
Okay.
And for 3, right?
Right. The husband had set an hour on his request for temporary relief.
Was the trial, is there anything in the record that suggested that the trial court's docket was such that, you know, we knew we needed a day, but we weren't going to get that day hearing time for, you know, 4 months, 5 months later. So we had to take what we could get, which was the 3 hours. I'm not asking whether that was the case. I'm asking whether there was anything in the record that showed that was the case.
There is nothing in the record to that point.
So really, if we boil it down to the discrete point, your argument is that this trial judge abused her discretion by holding the parties to the amount of time they had cleared and said was sufficient to have this matter heard.
Yes, okay. I am saying that, and I will say why. Because this often happens in the case law shows you run out of, you prepare for a hearing, there's insufficient time. And I think where the court abuses its discretion is if it wanted to hold the parties to the time, then it had to cut the wife's case off halfway through the time. It couldn't say you have to choose between cross-examination or presenting your case. And then I think secondarily, it's one thing to say, okay, I'm going to hold you the time for this hearing. But what the case law recognizes is if that time is not sufficient to hear the defense and you've only heard one side, then you may be able to put in a reasonable interim award, but you have to allow that continued hearing. So if there's a continued 3-hour hearing,
that goes to a secondary. I mean, you're right. We tell trial judges don't run your docket like a hockey game. It's, you know, it's not like as this last second expires and everything has to stop.
Right.
Is there anything that would prevent the former husband from simply filing a motion to modify the temporary relief order, and get a chance to put on his case and say, look, judge, we ran out of runway the last time. I'm now here to modify the temporary relief order. You remember, you know, we didn't have quite enough time to get done what we needed to get done. My client didn't have a chance to testify. We're now going to move to modify. And it would seem like you would have a self-evident explanation for the reason for the modification, which is that you never even got to hear from one of the parties. What prevents him from doing that, which would save everybody a lot of time, hassle, and money?
I think two things prevent him from doing that. I think the first is how hotly the judge rebuked him and said, I am not going to give you additional time.
For that hearing, for that day.
Right. But he said, can you continue and allow me to present my evidence? And she said, no, I've sent people to jail in less time than this. This is all I'm going to give you.
She gave him a chance to take his deposition and submit that, and that did not happen.
Right. And
so, I mean, that's why, you know, from her perspective, the judge's perspective, the parties mismanaged their time. And I know you're trying to put it on the judge, but as you read the transcript, it looks like the judge kept saying, hey, it's your time, use it as you want. Same thing we say here, actually, to people. You know, we try not to micromanage lawyers. We try to say, here's your time block. It's your time, use it as you want. And the judge seems to really have tried several times to sort of say, hey, I'm warning them, but it's your time, go ahead and do it. And then at the end, when they ran out, she said, look, go ahead and take his deposition, submit it, I'll review it before I rule. That wasn't even done. It's extremely hard to sort of find prejudice here when the remedy that was offered wasn't even taken advantage of.
So two things, you know, so that we're kind of blending. Everybody looks frozen. I want to make sure you can hear me. Two things. I mean, the first is the deposition issue, which you bring up. And I think that the deposition issue is clear that the case law doesn't say it's okay to just allow somebody to submit a deposition. And the case law says if you preserved an error and the judge has denied you that which the law requires, which
did anybody object? I mean, the judge said, you know, submit the deposition. Did anybody say, hey, that's not fair, objection, judge? Did anybody make any objections?
He did not object at that point, but he had twice objected to get the additional hearing time. And so the case law is that preserves the error that is you were entitled to the hearing time and that you're not required to accept something less than the law requires by submitting an affidavit.
Let me ask you a question on the same lines. The record reflects that the appellee put on the expert testimony and trial counsel for the appellant cross-examined. I don't know from reading the record if the trial court concluded that counsel for the appellant and the trial counsel for the appellant was dragging this out despite the warnings as to managing your time. Do we have to defer to the absence of any indication or any argument by trial counsel that, judge, there was a lot more information that came out than was expected. I objected to redundancy and cumulative testimony and so forth. And I've been put in a position where I had to cross-examine all this, and that's not enough time, and it was unanticipated. Was that argument made?
The way that you phrased it, not precisely, but I will say this: there was an argument made about the fact that the expert's testimony itself was a surprise. The parties had to exchange exhibits before this hearing, and nothing was said about the demonstrative exhibits the expert was going to use. And so at the hearing for the first time, the expert comes out with these demonstrative exhibits. They were going to try to get them introduced, except that was objected to. And then the court says, well, she can just testify to it. So so at the hearing for the first time, this accountant is going to testify to 3 times the amount of income the parties ever reported based on some speculative and not submitting the foundational evidence. And so that objection was made, and the objection was made that I need time to present the evidence that the husband has. I think what doubled down on the error here is not only did she not permit the husband to present his case and his testimony at a live hearing the same way the wife had, with live testimony, so the court could ask questions and weigh the demeanor, et cetera. But then the court faults him for not rebutting the evidence that the accountant provided. And again, I think what the cases recognize is you've got to give both sides a chance to present evidence in court. And
so, Ms. Norris, I don't mean to interrupt you, but
yes.
but this is a burning question for me. It wasn't clear to me at the end of the 2-hour allotted time for the wife's presentation that the husband's lawyer said, hey, judge, they're done with their time and I've only got an hour and I really need to use my hour. They're now encroaching into my time. I don't recall reading that in the transcript.
So the husband did not stop at 2 hours. He allowed the wife to continue presenting her case.
But why though? I mean, if the husband's now worried about this, he made no effort to protect himself.
I think he did make an effort to protect himself. And in light of the case law that says, well, if the time expires, there can be an interim reasonable award, and then you will get your time. I mean,
Well,
there's
but I
law
don't
that
understand
says
how the husband can now complain if at the end of the 2 hours that the wife had said, this is what we need, and the husband said, we only need an hour. At the end of the wife's allotted time, the husband did not make a strong record showing, judge, they've used their 2 hours. They are now encroaching into my time. I need this hour, you know, and set up for possible additional time. That was not done in this case.
But remember that,
and you know, as a trial judge, I've sat through this so many times. It's like a recurring nightmare where the parties never pick enough time. They're fighting over who's going to use what time. Invariably, they run out of time. Everybody wants more time. And that's why we have the backlog we have in the trial courts, because nobody uses the time correctly. And I don't understand how a husband can be here now complaining when he didn't at the end of 2 hours make a strong record showing, judge, they're now into my time. You know, it's hard to really sort of understand it.
well, I think you're putting, what would the result have been if he'd done that? Then the result would have been the continued hearing time that he was entitled to.
Well, I would certainly feel better sitting here listening to your case if I thought he fought for his own time. But the way I read this transcript, he just kind of let it bleed over and maybe was hoping for something. I'm not really sure, but he did not basically make a strong record showing, which, you know, I mean, Ms. Norris, you're an appellate lawyer. You know the importance of a strong record showing, and you don't have it in this case.
I would disagree that we don't have it in this case, because the court says, you know, I mean, he has to do cross-examination. This is the accountant's testimony. And yes, the court says, oh, I'm keeping time. But she doesn't, you know, but then there's no accommodation for the husband's case. And
let me ask you, Ms. Norris, at what point was it disclosed to Mr. Jaramillo that there was going to be a forensic accountant testifying at the temporary relief hearing?
That day.
Okay.
Yes.
That might have been, at that point, when it was disclosed to him, hey, look, here's a CPA, forensic accountant, is going to now testify. Did he say, whoa, stop? As a forensic accountant, there is no way we are going to be able to get through two different parties' testimony and a forensic accountant's testimony in 3 hours? Did he make that representation to the court? You know, I'm trying to get it that discreet, because you know, back in another day, I worked with forensic accountants. I've never heard of one getting through testimony in less than at least like a morning.
And keeping everybody in the room awake in the process.
That's a whole separate issue. But I mean, it's just a big chunk of time for forensic accountants to be able to lay down their qualifications, lay down everything that they went through, lay down their means, the way that they arrived at the conclusions, and then get through the conclusions. Did he say, stop the presses? If there's a forensic accountant, I need more time.
He did not. But I think some of the court's questions are sort of putting somebody in a bind. Because if he argues, oh, they're not going to have time at the beginning of the hearing when he hasn't seen what they're going to do, then it looks like he's obstructing because he's not giving them time to put on their case.
Well, but you know what they're going to do. They've brought a forensic accountant in. I mean, it's kind of self-evident what the reason why she's there, right?
Mm-hmm. And he tried to limit his cross-examination to the time period so that he could stay within what the wife had done. But I think, again, the case law is clear. Yes, I understand the judges, you run out of time. What the case law says is you run out of time, put in an interim order, and give the person a chance to come back. And without that express chance to come back, coming back on modification is a risk, because the judge can say, what's changed? Oh, I want to put in evidence that you wouldn't let me put in before. So
well, I think that's the argument. Judge, you will recall that when last we were here, we ran out of runway. We didn't have time because they sprung a forensic accountant on us, and that ate up all the time. The change is that you never even heard from one side of the case. Here's your chance to hear it. And if she doesn't do it, then you got a different case, right?
I don't know that you do, because there's case law saying that temporary support orders should not be revisited constantly. You have a judge who said, I'm not going to give you that opportunity. And it's a modification. And so what merits modification? And is it, you know, getting a second chance at a ruling that the judge said she wouldn't do? So I do think the judge, the court, yes, the court was in a bind. The husband was in a bind. The wife used up all of it on her case, and the case law says, okay, you can put in an interim award in a reasonable amount, give them a chance to come back. And there's no harm here. The wife had $500,000 in the bank. There could have been an interim award based in a reasonable amount.
And Ms. Norris, I know I've used up a lot, and I apologize. I only have one more question on this, and it's just because it just seems, I expect fully that we'll hear it from your friend, and it's this, is to some degree, what should we take into account of the fact that presumably the reason they had this forensic accountant here was at least in part because of the discovery problems and the discovery compliance problems that led up to this.
Yes, I do. Yeah. And I do want to talk
I want to hear your thoughts on that.
Yeah, because
Ms. Norris, let me just let you know, we're eating into your rebuttal time, but I'm going to give you a few more minutes so we can get through it, and opposing counsel will have the same amount of time, but just be mindful. You're going to start eating your time, but I'll let you know.
Sure. Yeah. So the discovery issue comes in because there's this argument made that that there didn't need to be the findings that the law obviously requires in case after case because of a lack of discovery. But the only case cited for that is one in which the husband had a continued course of conduct and then was sanctioned, the striking of pleadings. And in that one case, the court said, well, there wasn't evidence to make the findings. This case there was significant discovery in this case. We detailed it in the briefs. And in addition, there was a hearing 2 days before this hearing on the discovery issue in which the court declined to hold the husband in contempt, declined to hold him in willful contempt, went through all of what he had produced, almost 4 years of QuickBooks records, bank statements for personal and business accounts, et cetera, et cetera. The court didn't hold him in contempt, said you have 30 days to produce extra documents after resolving some differences on, was it the husband's obligation to go to the bank and get canceled checks, or was the wife supposed to subpoena those? So you didn't hold him in contempt, and then, has a hearing, and then all of a sudden the accountant testifies to this speculative, well, I don't know that money taken from a business account was spent on business expenses, so I'm going to assume it as income to the tune of over $200,000. And so this is not a case in which there was not evidence, hard evidence from which a court could have made a ruling. And I think that's really important here. There was the tax returns. I know they said they were understated, but there was also testimony on what the husband was spending per month on his financial affidavit. And then there was some of the testimony of the accountant that was based on, I know this expense was a personal expense. That would have permitted a finding of income around, 200,000 up to maybe 300,000. And that's more than you usually even have at a temporary relief hearing. So there was hard evidence to put in a reasonable award. The judge doubled down by just putting in, I don't know what it is. I'm not going to make a finding on the evidence, and I'm going to award an amount that exceeds the lower, the range, the lower end of the range here, and would only be really justified by the higher. So I do want to reserve a little time for rebuttal, and I'll rest on my briefs for on the competent substantial evidence that there really was, this was speculative. Thank you.
Very good, Ms. Norris. You'll have 4 minutes for rebuttal. And Ms. Anderson, you have a few extra minutes as well if you need it. Don't forget to unmute your microphone.
Okay, can you hear me?
Yes.
Okay, thank you. May it please the court, I'm Ingrid Anderson. I represent the wife, the appellee. First, I'd like to clarify a few items about the proceeding. There was a lot of questioning about the proceeding. The time was divided actually equally. It was an hour and a half to each party. The wife didn't get the 2 hours with one for the husband. The other point was about dragging out. Did the husband's counsel drag out the cross-examination of the forensic? I have a couple of examples where I believe it was. The forensic had been qualified as an expert with almost 30 years of experience. But the husband's counsel chose to voir dire the expert on the issue of whether the advice to the wife that it would be better to take the money from the sale of the house and invest it in another home rather than eat it up for living expenses. I would submit that that doesn't even require an expert to figure that out. That's kind of basic math. But he chose to voir dire the expert on that point after the expert had been, the forensic had been qualified as an expert with 30 years of experience.
Ms. Anderson, I know where you're going with this, and I'm just curious as I'm listening to this position. You know, as a judge, I just am really loath to micromanage a lawyer in their questioning. I mean, it's, you know, unless somebody's making an objection, you know, for a judge to inject themselves in to this very often. I know sometimes a judge will say, hey, move it on, move along, you know, or something like that. But I think you're asking a lot to think that a judge is going to split hairs and decide whether cross-examination is essential or not essential. I think lawyers need to ask the questions they need to ask, don't they? I mean, you've done this a long time. How do you feel when a judge tries to tell you what to do?
Oh, I agree with you. The judge did not interject. I was just pointing out the choice of the lawyer to spend his time doing that. And another example is he spent a decent amount of time going over the financial affidavit with the expert after the expert had testified that she did not prepare the financial affidavit. She had been so busy trying to trace all the income and double check and, you know, make the best of the information she had, that she was not even able to participate in the preparation of that. She did, I think, have a quick review at the end, but she did not prepare it. So that questioning, I also think, is a little bit suspect in terms of use of time, because he didn't know how long the hearing was for, and he had never objected in advance. If he knew that that amount of time was not enough, he could have filed a motion to continue in advance, or he could have not approved of the amount of time allotted. I have a couple more points on that. The deposition, the court allowed the husband to submit a deposition transcript that she promised that she would review, just as it was testimony. Now, one of the cases that the appellant cites regarding use of a deposition as opposed to live testimony involved the use of a deposition that was taken by another attorney, not the attorney handling the hearing, another attorney at some time prior to apparently that attorney taking over. Here, the deposition would have been after the wife had presented the entirety of her case. It would have been a very good, a suitable alternative to rescheduling and continuing. The husband had not been paying support for about 9 months, and the wife already had to liquidate, I think it was 2 major assets. I think it was her 2 most important assets just for support. To continue it, and obviously there is a pattern of delay by the husband in this case with the compliance with discovery. The discovery, there were 3 motions to compel. The husband never even signed the certificate of mandatory discovery, probably because one of the tax returns that he had included.
Let me pause you there, Ms. Anderson, before you get into, you know, any kind of speculation. You did make a point of about these discovery tiffs, about these discovery problems. Let me ask you though, at any point I can tell from the record, did the former wife, did Ms. Jaramillo ever just subpoena the bank records?
I don't I don't recall that she did, but I'm not 100% sure.
Why not? I mean, it just, you all are making a big deal about his non-compliance, his foot dragging, that he should be the one pulling out all the ledgers and the P&L statements and the, the accounting balances. Why not just subpoena the law firm's bank records? Why not subpoena the, the different ventures bank record? You know where they bank. Why not just do that?
Well, there were several, many different bank accounts, and some of them were not known initially at all. They weren't disclosed.
But the one, it just seems to me that you all are making this big deal out of why isn't he just giving us all of these, voluminous accounting records that would be held by their businesses, that she knows the businesses, right? I mean, she worked inside the law firm. I mean, she knows this stuff. So why not just subpoena it and cut to the chase instead of running up attorney's fees and taking up time and seeking trying to put folks in contempt? That I don't understand that.
Well, I think there were more records than what she could have gotten on her own. But I think the expert did do some kind of independent discovery. I know she called online went on to sunbiz.org just to find any potential companies that he might not be disclosing.
But
so
She was the office manager.
The ones
though.
you
She
know
would
about,
more about this than he
people were
did.
complaining consistently about. It's a third-party subpoena. You issue it. There's no objections. They don't have a dog in the fight. They give you everything. You pay for the cost of copies. Done. I don't understand, like, why the circuit court or us should be concerned with this, what you are describing as obstreperous discovery practices, when it just seems to me the easiest and obvious way to have resolved this would have just been third-party subpoena.
Well, I think that might have helped some, but I still think there would have been a lot of missing pieces. This was just what she could identify as income was about $350,000. And what she could find in spending was almost double that. It was over 600,000. So there was a lot of missing information. It wasn't just a simple third-party subpoena to a bank. And it was a temporary hearing. And I would submit that they thought they had enough for a temporary hearing. Temporary hearings often are, conducted without full disclosure.
I'm only raising that point because you all raise it, because you all's argument in your answer brief spends a great deal of time laying out why we had all these problems, we had all this discovery. So it's obviously important to you, or at least you believe it's important to your argument. I'm just trying to understand, well, okay, you're making that argument, but you're not explaining to me why you didn't just do this a different way. But I think I hear what you're saying is that, look, it was a temporary relief and we wanted to just go with what we had.
Well, I think that they tried very hard to get some numbers. And I think that there was just a lot of hiding involved. I don't think they could have found a definitive number without cooperation from the husband and discovery. The other thing that I just wanted to point out was the deposition would have, when the proposition was made during the hearing, husband's counsel said, fair enough. For him to complain now, and I think it is extraordinarily telling that he did not even bother to present what he thought was so imperative in his case, the husband's testimony. And regarding the fact that when did the husband know about the forensic, I don't think it's exactly clear from the record that it was a surprise at the time of the hearing. There had been all of these discovery issues going on for months. I find it hard to believe that the fact that there was a forensic was not revealed. And I would point out too that there were no expert interrogatories filed. And
well, but why would there be, unless they knew about the identity of an expert? Why? and you're at the temporary relief stage, why would you be sending that out?
Well, they would have discovered it if there was an expert by sending that out.
You know, obviously the trouble with this case is, and the irregularities that occurred, is the result was extreme. That's the problem. You know, the result was extreme, and as a judge, you should sort of weigh these things. How much irregularity you're going to tolerate versus what's the ultimate result. In this case, it's a $27,000 a month award against reportable income on his tax returns of about $240,000 a year. So the award itself, basically on its face, appears to eclipse his income. Now, I know there's all this argument about how his income could be $650 because his spending sort of reflected all that. We don't know. All we know is we have a fairly extreme award. And I know there's been efforts to say, well, it's kind of like it was in the prenup. Well, it really isn't. The prenup, called for $15,000 a month. $27,000 is a whole lot different. So how much should we on the appellate court consider that? Is that something that or should we just treat all cases the same, whether or not there is an extreme outcome or not?
Well, I think that it is something that you might want to factor in, but I think that is totally offset by the fact that he did sign a postnuptial. The appellant tried to make it out like it was very different than the actual award when it really wasn't. Husband agreed to pay $15,000 a month plus these car payment and insurance, things like that. And the thing that they harp on the most is the child support. The child support base figure was $2,500, but he had been paying many add-ons. This child was pampered to a certain extent. The parents wanted a superior education for this child, wanted to give him every advantage. He has some kind of learning or ADD disabilities, makes learning a bit harder. And so he was having tutors, he was having special treatment. All of those were being paid for by the husband. And he actually had been paying this before the filing.
Ms. Anderson, you're making the case for no good deed goes unpunished. He was doing this voluntarily. It's a lot different to do things voluntarily than being told you must do it.
I wouldn't exactly call it voluntarily because he did sign the agreement.
Yeah.
But there's still a pretty big spread between what he agreed to. I mean, I hear your point that, like, look, take the agreement. It is, at a minimum, it's evidence that he's recognizing he has this ability to cover this amount. But there's still a pretty good size spread between what he agreed to in the postnup and what the trial court ultimately
not really.
awarded.
I would say it was negligible at best. The 27 is not the right figure. She uses 27 a lot in her brief, but she does make a caveat that includes support paid to a different child from a different marriage. It was really 24, but it was 15 plus the car payment, etc., for the wife, and 25 for the base for the child support and the traditionally paid fees. He agreed in the postnup to actually pay private school tuition, which is a hefty sum. But the child was in public school, so he was not even having to pay that. He was having to, he could have used that money to pay some of these other add-ons. So there is not much difference between what he agreed to pay and what, in fact, the trial court ordered. So I would submit that he had the money. He had the money, whether he was paying in advance of an order being a good deed. He stopped, by the way, he stopped paying in October 2018, and that's when they started to get much more aggressive with the hearings on support and stuff. He stopped paying in 2018. And coincidentally, according to the postnuptial, that date sort of coincided with the date that under the postnuptial, both parties have been compliant with the postnuptial, by the way. Wife was to pay a fairly large sum in a tax payment. After that date, he stopped paying with the support. So, you know, you can draw your own conclusions from that.
I'm not sure that's very persuasive for your legal arguments, but okay.
Yeah, the legal arguments. The Hicks case. It is, to me, it's on point. It's directly on point. The court found that when a party prevents the court from accurately calculating an amount through the failure to fully and completely disclose financial information, that party will not be heard to complain when the court cannot and therefore does not make a specific calculation. That case was slightly different in that case, the husband had been defaulted and failed to show up at a deposition. But the court in that case didn't set aside the default, but basically allowed the husband to participate. So in effect, they canceled out the default. In this case, husband, 3 motions to compel, 2 motions for sanctions. The court awarded fees against the husband on 2 occasions. One was pending. The court admonished the husband more than once about his behavior. And the husband did not show up at one of the motions for sanctions. I think there was some excuse about him being sick or somebody he knew being sick, but the court laid into him. She said she was tired of this, you know, you need to show up. If you look at this record closely in its entirety, husband did not want to do anything under oath. He did not sign the certificate of mandatory disclosure. He does not show up at hearings where he might be called to testify about some of his actions. And when he has the opportunity to have a deposition where he could present his case, what he thought was so egregious that he not be allowed during the hearing, he doesn't do it. So there are at least 3 occasions when he has the opportunity to say something on his behalf. He doesn't do it. And he is a licensed attorney, so I believe he's quite cognizant of the fact that lying in one of these instances may have repercussions. So this is a court of equity. I understand there are large sums involved, but this couple lived a very high lifestyle. Their finances are very complicated. And when the wife left the firm, she was walked out the door, did not have access to any of the documents of the businesses. She was escorted out. And so they needed the documents from the husband. So I think the argument on the Hicks case is on point. I think it's dispositive in this case, both regarding the child support and the alimony award. I think the only case they cite about coming to a child support, the primary case they cite about coming to a child support calculation regardless of sufficient financial information is the Blum case. And in that case, was just so totally different. In that case, there was no independent child support award at all. It was an unallocated award, and it did not even involve a dollar figure. It was simply, husband, you pay the mortgage, pay some insurance, pay some medical bills, but there was no, I think there were a couple of financial affidavits, but that was it. There was no way to even evaluate child support in that instance, which is not what we have here. Plus, I have to keep emphasizing the postnuptial. He agreed to all this. And the difference, despite the way of trying to manipulate the phrasing of some of the wording in the postnuptial and the temporary order, these were very similar, almost identical. And I believe that is why the trial court ordered it, because it was what he had already agreed to. And there is a finding in there about the postnuptial. It is mentioned in the order, and it is acknowledged that it hasn't been declared valid yet. But this, from an equity point of view, this does not look good for the husband at all, nor on a legal point of view. I see no reason for reversal in this highly discretionary temporary support award case. This is, the standard of review is abuse of discretion, but I think we all know that temporary support awards are among the most discretionary of orders. How's my time coming?
Ms. Anderson, you have about a minute left.
A minute left? Okay. Does anyone else have any last minute questions? I think I've probably covered my high points. Anything bothering anybody?
I think we've asked.
Well, like about this case or otherwise?
Feel great.
Well, we can talk about it otherwise later, but about this case.
Thank you. If you're all done, we're set.
Oh, well, one last point was, I think there was a lot mentioned in the appellate brief about the competency of the evidence and the making of assumptions. The case that they cite, the Perez case, the key was reasonable assumptions. I think in this case, all of the alleged assumptions were quite reasonable. The expert testified that she followed all the rules of accounting principles, and she really did bend over backwards to try to trace everything that she could find on his income. And I think that's about it. I thank you for your time and your good questioning. Thank you.
Thank you, Ms. Anderson. Ms. Norris, you have 4 minutes.
Thank you, Your Honors. I want to make a couple clarifications on factual things and then a couple points. The first, I will confirm with what Ms. Anderson said. Over 24,000 ordered in this order, which is in addition to a prior child support order for another child of about 2,500, I believe, was the evidence. So it's a total of 27 in court ordered, over 24,000 for this. As to the expert, actually the husband's counsel conceded that the expert was an expert and did not voir dire. He did question the expert on whether or not she had examined the wife's income or the wife's expenses. That was pretty short order, and then spent a significant amount of time having to look at what she relied on for income.
I think he voir dired the expert on her competency to render financial advice specifically to clients and how many times she had testified on that. But that was relatively short from what I recall from the transcript.
Right. I would agree with that. I do recall that.
I don't want to spend a lot of time on the continuance issue, but one of the things that does bother me is when the judge said, you can take the deposition of your client, he didn't object saying, Judge, you need to see this person live. In fact, he said, Judge, that's fine, but instead of the 2 weeks that you're giving me to do it, I need 3 weeks. So why is that not essentially a waiver of the complaint about the continuance issue?
I don't think it's a waiver because he'd already pressed the issue that was an error. He was entitled to the hearing. That's what the case law says. And then he did say fair enough and backed off. And then, there was some discussion about how long the court would give them. But I don't think it's a waiver. And I think in particular, I think this is the totality of the circumstances here, as Judge Morris had mentioned. You have a limited hearing, you have some hard evidence, you have evidence of their tax returns, which would support, over $200,000 in income. You have some hard evidence, maybe up to 300 from some testimony of in-kind expenses. But the largest portion here is this testimony of the accountant that says, there's about 200,000 from a business account that I don't know what it was spent on. So if he can prove to me that it was spent on the business, then I will lower the income or spending amounts. It's a huge portion of both amounts. And that's not competent evidence under Perez. I would also note, as the court pointed out, the wife was the business manager. She knew the finances. She didn't put herself under oath to talk about that either. So this isn't a case where the court, like Hicks, I can't make a calculation. The court has financial affidavits. The court has the tax returns both parties signed. The court has a wife who was a business manager and significant discovery. It can't make a speculative one, and it has to make findings so this court can tell whether or not it's speculative or not. And I would say, yeah, the wife didn't go out of her way to get the extra evidence. And I would say why? Because the amount could only go down. Because if that evidence came in and it was business expenses under the accountant's own testimony, that would lower the amount. So she wouldn't be entitled to a support order at a $650,000 that never had been, documented. It was more close to the $300,000. And this award over $24,000 wipes that out. The lack of findings makes that error even worse. And then the reliance on a lack of findings and not giving the husband the continued hearing was an abuse of discretion, and this court should reverse and permit further proceedings.
Very good. Thank you both for the presentation. You may exit the courtroom. The next case is Sabre Real Estate versus Alagold Communities.
Thank you.
Thank you.